Heard's third counterclaim didn't survive more than a couple of months in the litigation process. So why did she bring it? And do we have a reason to suspect that it may have been for one of the improper purposes identified in Rule 3.1? We're going to take a look at her Twitter subpoena. On August 10th of 2020, Amber Heard filed her counterclaim. But in an interesting twist of timing, 3 days before that, she started the process of issuing her subpoena for business records to Twitter. Now, on the one hand, issuing your subpoena before you've even filed your claim might be putting the cart before the horse from a merits standpoint, but more significantly in this context, it speaks to the priority of the party when the effort is made to pursue the discovery before the claim has even been lodged. After giving notice of the subpoena to Johnny Depp, Amber Heard then served the subpoena on Twitter. It was what we call a subpoena ducis tecum, or a document production subpoena, meaning that it's requesting that certain documents, materials, records, something tangible be turned over to the requesting party, as opposed to the type of subpoena that is requesting testimony. The information Amber Heard was looking for was IP addresses. For the accounts at issue, she wanted the IP addresses for the device where the account had been registered, any device that the account had ever logged into, and any device from which the account had ever tweeted. It also sought information dealing with certain actions taken against the account, such as rate limiting or any type of action for a violation of Twitter's terms of service. Amber Heard wanted comprehensive IP address information for over 200 Twitter accounts, without any showing that these accounts were inauthentic, without any showing that these accounts had any communication or link with Johnny Depp or Adam Waldman, and without any showing of any wrongdoing whatsoever by a single one of these Twitter users. Remember, the gist of her counterclaim wasn't that people were sending her obscene or threatening or harassing messages because she couldn't substantiate her Computer Crimes Act claim. Her beef is that these accounts may have signed the change.org petition, or heaven forbid, they may have tweeted, "I love you, Adam Waldman." Getting this IP address information was such a high priority for Amber Heard that when Twitter did not immediately turn over all of the requested information within 30 days, Amber Heard's California lawyers went to court in California to try to start the process of compelling Twitter to produce the requested information. And so we see Amber Heard first issuing the subpoena not only at the earliest possible opportunity, but even before the earliest possible opportunity, and then instantly, as soon as possible, when that information is not provided, going to court to try to force it to come out. In an effort to persuade the court that her request was justifiable and should be enforced, Amber Heard represents that her purpose is not to seek any personal information or private information from individual users, and that it would not result in any unmasking of individual Twitter users. Instead, she argued, this information was necessary to investigate and substantiate and verify the claims in her third counterclaim dealing with the coordination she alleged between Johnny Depp, Adam Waldman, and various inauthentic Twitter accounts. At this point, Twitter gets involved. And so they send a letter from their lawyer setting forth their objections to this subpoena. Several of them are fairly self-interested. The subpoena is broad. The subpoena is burdensome. The subpoena would require the disclosure of trade secrets. But other objections dealt with the privacy concerns of Twitter's users. Significantly, Twitter noted that the overwhelming majority of these Twitter accounts were anonymous users, and the First Amendment protects a speaker's right to retain their anonymity. Consequently, in order to unmask or dox an anonymous online speaker, certain protections are in place and standards must be met for that request to be justified. Because of the protection the First Amendment gives to anonymous speakers, the requester of that information has to establish a compelling need for the speaker's identity in order for that information to be disclosed without their consent. So after Twitter's November 2020 letter, the issue doesn't get resolved. And then, as you'll recall, on January 4th of 2021, Judge White dismissed count 3 of Amber Heard's counterclaim, finding that she did not allege facts that would support a violation of the Virginia Computer Crimes Act. California, just like Virginia, has an ethical rule requiring that for an attorney to bring or maintain an action in court, they must have a reasonable factual and legal basis for doing so, and they must be doing it for a proper purpose. Likewise, California has a signature requirement that indicates that when you file a document in court in California, by signing that document, you are representing, after having done a reasonable inquiry, you believe that your factual assertions are well-grounded, are likely to have evidentiary support, and are justified by the law, not done for any improper purpose. So you might think, gosh, now that the counterclaim has been thrown out and the basis for Amber Heard's request to Twitter has been completely undermined, she's probably going to walk away from it, right? Well, that sure isn't what happened. Instead, about 3 weeks later, Amber Heard's California lawyers double down and they go back to court in California to try to get the information. They continue to insist that the subpoena does not request any personal or private information and would not result in any unmasking of anonymous users. And she continues to assert that this information is needed to prove whether Johnny Depp was defaming her through these other Twitter accounts. So notice what doesn't get mentioned in Amber Heard's status report: the First Amendment and the fact that her counterclaim got dismissed. Now, if you think of the court process as a truth-finding type of function, then you might be thinking, why doesn't she have an obligation to mention those things? Isn't that something that she should be required to do? Well, so it turns out there is a rule for that as well. And in California, it's Rule 3.3, candor to the tribunal. So that rule makes it clear that a lawyer cannot knowingly make false statements of fact or law to a tribunal and must correct any false statements that have previously been made. They may not fail to disclose controlling legal authority in their jurisdiction, and they may not misquote the law to a court. And lastly, they cannot knowingly offer false evidence. What stands out about Rule 3.3 is that while it prohibits attorneys from knowingly providing false information to the court, it is silent on the implications of misleading the court by omission. There is no duty to disclose facts in Rule 3.3. Now, there are some reasons for this. Confidentiality is an important concern. If an attorney had a duty to disclose facts to the court, that could potentially undermine the nature of the attorney-client relationship. But another reason is because courts expect that in an adversarial system, the other side has the incentive to make sure that the court is fully informed of all of the pertinent facts. And so fortunately, we do see that happen in this case. Johnny comes out blasting in his own status report to make sure that the court is fully aware that this counterclaim that justified the entire course of action is no longer viable. It has been dismissed in Virginia, therefore it cannot be grounds for discovery processes to provide some type of relevance for the inquiry that she is trying to engage in. But we're not done there, because Camille Vasquez is also going to point out there's some law here that you're not mentioning when you tell the court that IP addresses aren't private information, aren't personal information. Actually, under California law, they are. They're specifically defined as private, confidential information. And Twitter, likewise, steps in to point out that an IP address can be used to unmask an anonymous speaker. And in fact, for an attorney who has access to the power of discovery tools, it is as simple as issuing a subpoena to an internet service provider in order to obtain the name and identifying information of the person associated with any IP address. So where does this leave us with the ethical questions? When it comes to not disclosing the fact that the counterclaim had been dismissed, it looks like under Rule 3.3, Amber Heard's lawyers are probably off the hook on that one, since omissions of factual information typically aren't going to be considered unethical. But we still have a couple of problems. We have this failure to disclose the law statutorily written in California that provides that IP addresses are personal information, therefore they are entitled to some type of protection, completely contrary to the position that the attorney is taking in court. That's potentially problematic, but really pales in comparison to this overarching problem that is really called into question by the timeline of events here, the prioritization of this subpoena, and the nature of the information that's being requested. We have to bear in mind that doxing is a strategy that seems to be something that Amber Heard's allies are pretty comfortable with. We're seeing right now attacks on that umbrella guy who has an enormous following and has put out a lot of information about the Johnny Depp and Amber Heard case. That's not the first time we've seen it, though. There have been instances in the past where high-profile supporters of Johnny Depp, who had been anonymous on Twitter, were also doxxed and publicly revealed without their consent. So while it's one thing for a self-obsessed narcissist to employ these types of tactics while simultaneously hiding behind the First Amendment and the ACLU, it's quite another thing for an attorney to be complicit in using the legal process to silence a client's critics. And given here the inability to factually substantiate the counterclaim, the timing of the pursuit of personal information from Twitter, and the history of doxing, including the reference to what Amber's team might do with that information, in my opinion, this raises serious questions about Amber Heard's team's compliance with Rule 3.1. So we've looked at claims that have dubious factual merit. We have looked at improper purposes for litigation. In our next video, we're going to turn to legally frivolous arguments. And we're going to be looking at that through the lens of the argument that the UK trial should have foreclosed a trial in the state of Virginia. Now, this is an argument that Elaine is already setting up to be the star of her appeal. So we're going to take a look at that argument, the way that she presented it, and then we're going to consider whether that might be a risky maneuver for her in the Court of Appeals. Join me there.